Dear entrepreneur, dear startupper, most of the activities of your company depend on interactions with other persons. Since such interactions constitute key elements of your business, they are usually formalized in legal acts called commercial contracts. In these cases, you rely on contract law professionals, but your contribution remains crucial. You are the visionary person behind your company, and as such, you need to understand how contracts are shaped to ensure that they are aligned with your plans. Thus, knowing the basics of contract law is a major asset. To familiarize you with commercial contracts, I propose to decode together the content and form of these legal acts. In this first episode, we will discuss the supreme rules that govern contracts. Welcome to this first episode, which is for information purposes only and not for advice. My name is Mathieu Rimbaquier. I specialize in life sciences with a triple expertise in R&D biomedical sciences, business development, and law, mainly Swiss law, which I particularly like. Athletes will tell you that to excel in any discipline, knowing the rules is the first step. Since a contract is a legal act, the rules governing it are found in the law. Stated in this way, the approach seems obvious, but its application to a specific case may be complex because of the heterogeneity of the law around the globe. We are therefore led to consider the different types of legal systems that exist on Earth today. Common law applies to states that experience a historical Anglo-Saxon influence, such as the United States of America or the Commonwealth of Australia. Under this legal system, the judge renders a decision based on previous local judgments in similar cases. Therefore, common law is also known as judicial precedent, judgment law, or case law. To visualize this aspect, think of American courtroom dramas. They are full of references to case law. For example, remember the film Runaway Jury, based on the novel by American lawyer John Grisham. Recall in particular the scene in which a blind man cites a specific legal case in order to convince the judge to let him serve as a juror. With that said, let's continue our overview. In some states, such as the Republic of India, the legal system is mixed. It combines common law with other legal systems. In certain situations, in fact, in the vast majority of states, the system is fundamentally different. Currently, civil law represents the most prominent legal system on Earth. Unlike common law, here case law is secondary. To keep it simple, civil law refers primarily to a written law code, composed of short sections that define rules in general terms. In civil law states, the written codes are often inspired by the body of laws of the ancient Roman Empire, by Germanic law codes, or by the French Napoleonic Code. The influence of civil law turns out to be broad, and is sometimes combined with other legal systems, as illustrated on this map. You will notably identify the People's Republic of China and Japan in this category. Now, I would like to highlight another category. Some specific geographical areas are jointly influenced by civil law and common law. These mixed systems apply, for example, to the Republic of South Africa, the Canadian province of Quebec, and the US state of Louisiana. Our overview is not complete. Additional legal systems exist. As I'm not familiar with them, I will only mention them. These other legal systems are based wholly or partly on customary law or on religious law, such as canon law for Christians, Jewish law, or Islamic law. As a take-home message, you may recall that the majority of states, around 150, refer to a system based on or related to civil law. Dear entrepreneur, If you believe that the situation is too complex, take a deep breath and relax. We're not done yet. Woosah! Given the increasingly international nature of companies' activities, you may wonder which law will apply to your next contract. Predictability is essential in business. It is a crucial issue since the applicable law defines the interpretation of the entire contract. In common law systems, it will then be necessary to refer to the conflict of law rules. In civil law systems, these rules are known as private international law. Do not be confused by the term international. Indeed, private international law refers to domestic private law that applies to international matters. Simply put, it mainly governs, under certain conditions, the choice of law and the choice of jurisdiction, also called choice of court. It is a question of identifying the circumstances in which domestic law permits choice of court on the domestic territory. It is a matter of defining when a local judge has jurisdiction. If you consider Swiss private international law, it will only specify the rules applying to Swiss courts. And if a domestic jurisdiction is recognized as competent, the judge will apply the law in force locally, notably the domestic private international law. Note that in the European Union, conventions and regulations harmonize conflict of laws. As you can see, the legal field is quite complex even for an insider. There is no single way to define a contract. I therefore invite you to call on a legal professional to negotiate or draft your own contracts. This being said, the economy has globalized, which has pushed contract law to become more homogeneous. Nowadays, agreements between companies are mostly drafted in English, and their structure is standardized to a certain extent according to international usage. Thus, in the international business world, it is possible to refer to models in written form for commercial contracts. This simplifies the work of legal professionals, and non-specialists can at last rely on a reading grid with confidence. Dear entrepreneur, this is great news. These commercial contract templates can be useful almost anywhere in the world. Now, let's try to be practical. As a very first step in decoding a commercial contract, we must immediately find out which legal system and law govern the legal act. These supreme rules are found at the end of the written document, just before the signatures. You may read the following: the present contract shall be governed by Swiss law. Such a clause is called choice of law. It defines the applicable law to the contract. But the legal mechanism is not so simple. You must first identify who is officially authorized to validate the applicable law. Obviously, this situation is only reached when a litigation takes place in a specific jurisdiction, and there only the judge in charge defines the applicable law. From a formal point of view, the powers of the judicial branch of the local state government are vested in the local judge. To act methodically, one must first consider the conflict of law rules, then the place of jurisdiction, or the competent court if you prefer, and finally the applicable law. The conflict of law rules and the place of jurisdiction are defined by the choice of court clause. Let's take a simple example. Any dispute arising out of or in relation with the present contract shall be submitted to the courts of Geneva, Switzerland. This means that any dispute relating to the contract must be brought before a court in Geneva, Switzerland. Depending on the legal aspect involved, for example, consumer law, labor law, real estate law, or intellectual property law, a specialized Geneva judge will ensure that he/she has the legal authority to handle the case. If the conclusion is positive, the judge will apply the local law in force, Swiss law in our scenario. The choice of court and choice of law clauses will then be valid in our example. At this point in our exchange, you are probably wondering why I like Swiss law so much, which is civil law, by the way. My answer is that I find Swiss law very flexible. In most situations, especially in commercial transactions, there is no particular connection required for a contract to be subject to Swiss law. Thus, Swiss law is often valued as a neutral legal tool in the case of contracts involving parties from different states. Swiss law frequently governs contracts in international matters. Consider, for example, that Swiss private international law allows that a Swiss law contract between a Brazilian company and a Vietnamese company be executed in Angola. It is difficult to be more flexible, isn't it? Under common law, the legal mechanics of choice of court and choice of law clauses are somewhat slightly different, but the general principle remains the same. The judge will first ensure that he/she has the legal authority to deal with the dispute related to the contract of interest. It should also be kept in mind that the legal nature of contracts is conditioned by several layers of rules. For example, many contracts with a commercial purpose contain an arbitration clause. This arbitration clause replaces the choice of court clause and affects the choice of law. As a brief explanation, note that arbitration is a form of alternative dispute resolution. Parties voluntarily agree to abandon their right to judicial relief and, instead, they enter into a contract of arbitration. Such a contract creates a customized private system of adjudication. In arbitration, the parties can choose the applicable law and even their own tribunal, with the selected expert judges being called arbitrators. In addition, the parties frequently decide that the work of the court is of a confidential nature in order to protect their trade secrets and other key information. Let's stop here the explanation. This point goes beyond the scope of our introductory session. On a lighter note, you may wonder why choice of court and choice of law clauses are included at the end of the contract. Probably to make it easier for the signatories. Imagine the situation. You are about to sign an important contract. Your legal advisor has reviewed the contract beforehand. However, even at the last minute, you can check at a glance whether the supreme rules of the contract are the ones that suit you. Do you want Swiss law and Geneva jurisdiction to govern this legal act? Hop, with a quick movement of the eyes upwards, you read, "The present contract shall be governed by Swiss law. Any dispute arising out of or in relation with the present contract shall be submitted to the courts of Geneva, Switzerland." Excellent! Now all you have to do is sign and concentrate on interacting with the contracting parties to develop your own business. With that, we conclude the introduction to decoding commercial contracts. In our next episode, we will discuss the legal definition of a contract, and in the subsequent sessions, we will dive into the actual content of contracts.